Hello, ladies and gentlemen, and welcome to the final of the National Speed Mooting Competition 2021, sponsored by BPP University Law School. So this is the final of the competition. We've had competitors competing all day long to reach this stage. And the last two competitors that we have are Georgina Lane, who will be representing the appellant, and Chloe Yeung, who will be representing the respondent. Georgina, when you're ready, if you would like to present your submissions.
Thank you, my lords. May it please the court, my name is Miss Lane and I appear on behalf of the appellant in this matter. My learned friend, Miss Yeung, represents the respondent. The basis of this appeal is that the decision of the High Court and Court of Appeal be overturned for three reasons. First, the rule in the Crown against Brown is by no means absolute, and there are clear exceptions to it. Second, the current case does fall within a recognised exception, applying the Crown against Barnes. Third, if the court is of the view that this case is not sufficiently analogous to the recognised exception, it will be submitted that a new exception can be created in its own right. If I may first draw your lordship's attention to the case of the Crown against Brown at 1994 AC 212, which your lordships may find at page 47 of the e-bundle. Would your lordships care for a summary of the facts of this case?
No, you can take it as read. We're familiar with the facts of any case that you may cite to us this afternoon. Thank you.
I'm grateful. And at this time, may I request to dispense with formal citations?
Yes, you could just refer to the case name. Thank you.
Thank you, my lords. The case of the Crown against Brown established that a person generally cannot consent to serious harm. Whilst this is the general rule, this is by no means the absolute rule, and there are several recognised exceptions to it. It is respectfully submitted that the learned trial judge was wrong not to give closer consideration to these recognised exceptions and the application of them by analogy to the current case. This leads me on to my second submission. Bodily harm inflicted by consent in a professional context is a clear exception to the general rule applying the Crown against Barnes, which your lordship may find at page 30 of the e-bundle. Whilst there are dissimilarities between Barnes and the current case, it is submitted that if a player can give consent to being injured within the context of the game, it is illogical to prevent him from giving consent to the infliction of harm when the net result is, in fact, to enhance his professional career.
Ms. Lane, if you could just address me on a point in relation to Barnes. But even in that case, it was stated that the limit of the section, the exception in relation to professional sport, was within the playing of the game and also within the rules of that game. I'm struggling to see how that case applies in the instant case in it, where we're talking about surgery entirely out with the process of the game.
Whilst the appellant, thank you for your question, my lord, I'm grateful. Whilst the appellant recognises that there is no direct comparison between the Crown against Barnes and the current case, given that this occurred outside of the context of the game, the point we wish to make is that it would be illogical for an individual to be able to consent, to be able to impliedly consent to serious harm within the context of the game, but not for an individual, such as the case with Mr. Panettiere, to be able to explicitly consent to harm sustained in pursuit of his career within the game.
There's a substantial difference between a bad tackle and an amputated finger, though, is it not?
There is, of course, a valid difference between that and the permanent amputation of Mr. Panettiere's finger is, of course, a very serious consequence. However, Mr. Panettiere is a fully informed adult and he has given his explicit consent to the harm in pursuit of his professional career within the game of cricket. Whereas in the Crown against Barnes, it was an excessively, what they had to consider was whether it was an excessively late tackle and whether the victim had impliedly consented. So there is also a difference there in that Mr. Panettiere was able to provide his explicit consent to the harm being caused.
Thank you.
Thank you, my lord. Furthermore, as was held in Barnes, a criminal prosecution should be reserved for those situations where the conduct is sufficiently grave to be properly categorized as criminal. It is submitted that the current case does not constitute sufficiently grave circumstances. Whilst the amputation of a finger is of course grave in itself, there were no complications with the procedure, and it was performed correctly by a medical professional and enabled Mr. Panettiere, who provided explicit and informed consent, to participate in the World Cup and further his professional career. This has clearly also not hindered his ability to use his hand in his professional career, and we may infer his daily life. If, however, the court is of the view that this case is not sufficiently analogous to this established exception, it is further submitted that it should stand for an exception in its own right. And this leads me on to my third and final submission. It is submitted that the court should create a new exception to accommodate defendants and Mr. Panettiere's position for two reasons. First, there were no seriously detrimental consequences to this procedure, and as such, there is no justification for this court restricting either the defendant's or the patient's personal autonomy. This case can be distinguished from the case of the Crown against BM, where the defendant had no medical qualifications equipping him to perform the surgical procedures. In the current case, the defendant, Mr. Newman, is a private surgeon who is necessarily equipped to perform the procedure, consented to by Mr. Panettiere, a fully informed, responsible adult.
Counsel, forgive me for interrupting. I'm struggling with this submission slightly. Are you arguing that this is creating a new exception, or that we should find this fits under the medical exception that already exists? You've mentioned medical procedures on a number of different occasions and the medical qualifications of those involved. And I struggle to see how it would be an entirely new exception when this appears to be a medical exception that's gone beyond the limits of that particular exception that's allowed.
Our submission here is that whilst there already are recognised exceptions which may be extended, for example, within medical treatment and sport, if the court is of the opinion that this does not fall directly within either of those recognised exceptions, for reasons suggested by the court or by my learned friend, then this circumstance can still be considered as a new exception, drawing on analogies with already established exceptions.
Such as which exceptions would you be saying it's analogous to?
Most analogous to medical treatment, in the sense that it was performed by a medical professional and it is a medical procedure that took place in a private hospital. And that's it. On those points, that's where it can be distinguished from the Crown against BM, where they were reluctant to extend the already established exception or create a new exception due to the policy implications with allowing an unqualified individual to perform body modification procedures.
Are you saying those considerations in terms of the public policy considerations don't exist in this case?
I would say the public policy considerations in the current case are much lesser in cases such as the Crown against BM or the Crown against Aitken, where there are much more dangerous consequences of creating a new exception, which is why the court has been more reluctant to do this in the past.
Thank you, counsel.
Thank you, my lord. Second, it is submitted that far more harmful assaults have been allowed under the defence of consent. In the Crown against Aitken, which your lordships may find at page 14 of the e-bundle,
Thank you.
3 RAF officers set fire to the victim's fire-resistant suit, causing severe burns to the victim. It would seem illogical for consent to be allowed as a defence in the Crown against Aitken, where there was no social utility to the defendant's actions and the victim protested, but for consent to not be allowed in the current case, where Mr. Panettiere provided fully informed consent and the procedure enabled him to not only take part in the World Cup, but emerge as one of the tournament's best bowlers. To conclude, it has been submitted that the general rule in the Crown against Brown is by no means absolute. The exception established in the Crown against Barnes can be applied by analogy to the current case on grounds that the procedure enabled Mr. Panettiere to play in the World Cup and further his professional career. It has been submitted in the alternative, however, that this case can stand for an exception in its own right, given the social utility of the procedure and respecting the autonomy of the defendant and Mr. Panettiere. Unless I can assist your lordships any further, that does conclude my submissions.
Thank you very much indeed, Miss Lane. Thank you. Can we now hear from counsel for the respondent? Thank you very much indeed. Miss Yeung, thank you.
Good afternoon. If I could just first double check that my audio is fine and clear, just to make sure.
Yes, thank you. Certainly from my perspective, thank you, Miss Yeung. Thank you.
Thank you. And am I good to proceed whenever?
Yes, Miss Yeung, if you'd like to address the court at your convenience. Thank you.
Thank you. May it please the court, my name is Chloe Yeung, and I appear on behalf of the respondents, the Crown, in this case today. My lord, the respondents' submissions are twofold. First, that under current law, the appellant's actions do not fall under any exceptional categories where consent would be a valid defense. And second, that the court should therefore not be minded to create a wholly new exception. My lords, if I could at this point request to dispense of all case citations.
Yes, no need for case citations and no need to refer to the facts of any case. We've read all those beforehand and we are comfortable and familiar with the facts of any cases which may be cited to us this afternoon.
I'm grateful, my lord. With your lordship's permission, I will now move to the first submission.
Thank you.
As a general rule, my lords and ladies, one cannot consent to violent acts resulting in grievous bodily harm unless it falls within recognized exceptional categories of regulated and organized sporting activities, surgery, and tattooing, and so on. And these have been very thoroughly established in the case of Brown. It is submitted by the respondents that the instant case cannot be clearly distinguished, can be clearly distinguished from these categories. And I will address each of these in turn. First, to address the category of medical surgery. It is submitted that the present case can be distinguished from surgery on the ground of necessity. This refers to the preservation of life or overriding medical needs or overarching medical benefit. If I could
yes,
first,
Miss Yeung, thank you.
Yes, my lord.
I know you say that I take your point of necessity, but is it not the case that there are several cosmetic procedures that are commonly performed and are performed which are not medically necessary, but yet would otherwise amount to GBH, for example, a breast enhancement, nose job, or a vasectomy?
Yes, I'm grateful, my lord. If I would first then address such examples of cosmetic surgery to address your lordship's question, it is submitted that cosmetic surgery concerns the enhancement of looks and features, which is inherently different from the mutilation of a body part. There is a huge difference, it is submitted, between being able to alter slightly some of your bodily or facial features in order to make yourself look a certain way, and to completely mutilate a body part, in this case, the ring finger. And it's submitted that even though they may on the surface be the same, that cosmetic surgery addresses a very different issue than the one in question today.
I noticed you used the word mutilate. Could it be said to be mutilation even though the surgery is carried out for a purpose, not on some whim? I mean, it's agreed by all parties that Mr. Panettiere has had this surgery in the first place to improve his cricketing ability, not, as I say, not just because he's tired of his ring finger and wishes it removed.
Certainly, my lord. Perhaps if I could change the word mutilation to amputation, it is still submitted that the principle would stand. And in fact, the word amputation is used within the bundle itself. But the word amputation itself suggests the complete removal of a body part which it is still submitted, is inherently different from cosmetic surgery, which involves minor alterations to one's facial or bodily features, precisely because such enhancements are designed to be subtle and natural and are on that ground, not least on that ground, completely different from the purpose and the effect of the surgery in question today, if that addresses your lordship's question.
I may take issue with some of the points raised in respect to subtle and natural, but I believe I see what you're driving at, Ms. Yeung. Thank you.
I'm grateful, my lord. So to briefly continue on the point of necessity, in the judgment of BM, it is stated that the law cannot recognize consent to surgical treatment where there is no medical justification for it. And this does not exist in the instant case, as the facts plainly state. First, this operation carried no therapeutic benefit. Second, the injury was not career-ending, as Mr. Panacea would be fully fit in less than a year. Second, to address the category of sports, it is submitted that the surgery in question is far from being taken in a sporting or, as my learned friend has put it, a professional context. This is on the facts not a case where one athlete has unintentionally injured another within well-defined playing rules. This is a case where there is a non-participant of a sports game who has intentionally inflicted serious bodily harm upon another. This therefore plainly does not fall within the ambit of the judgment in Barnes, which imposed clear restrictions upon the applicability of its rules. Excuse me.
If I could just interrupt you there for a moment.
Yes, my lord.
Aren't we dealing with something of a paradox situation? Because if your argument is right, we sanction an act which can actually result in very serious injury, such as breaking a leg, which could in fact then completely ruin and curtail a professional footballer's career. Whereas here, aren't we dealing with a procedure which in fact has gone on to enhance the cricketer's performance? How do we square the circle there, Miss Yeung?
I'm grateful for that question, my lord. If I could address that with two responses. First of all, it is submitted that the court today should not only look at this particular appellant, this particular bowler, and this particular surgery in order to determine the legitimacy of validating this consent in this situation. My lords, this is well within my second submission, but I perhaps will address it very briefly right now. If I could refer your lordships to page 69 of the bundle.
Yep.
This is the case of Brown, starting with the paragraph, starting with "be that as it may."
Yep.
It is stated in the law that in considering the public interest, it would be wrong to look only at the activities of the appellants alone. We must therefore consider the possibility that these activities are practiced by others who are not so controlled or responsible as the appellants claimed to be. My lords and ladies, this court has the duty to look beyond this individual appellant and Mr. Panacea, and to recognize the harm of setting this precedent for wider social implications. It is not sufficient to say that this particular type of surgery or this particular type of grievous bodily harm should be permitted simply because Mr. Panacea perhaps had the resources or had the money or had the luck of being able to find a well-qualified doctor for his surgery, therefore legitimizing the principle of his mutilation, which would otherwise be a crime. My lords, in the same way, the court cannot find that the consent can alone be found simply on the quality of work done on the surgery itself. And this can be found, again, in the case of BM, particularly at paragraph 42, for your lordship's reference if you so need it. My lord,
sorry to interrupt you again, Ms. Yeung, but aren't we seriously restricting bodily autonomy? That there have been developments in other fields of law since BM and Brown. The courts are much more aware of an individual's right to individuality and, as is used, the expression bodily autonomy. If we accede to the respondent submissions, aren't we basically saying that we're imposing a nanny state upon individuals? And because we don't think this should happen, you have to conform in the way that we have dictated.
Certainly, my lord, I understand your question. However, it is submitted that even if this sort of exception or the validation of consent as a defense could perhaps apply to harms such as common assault or the infliction of actual bodily harm, it is still submitted that current established law has a uniquely high threshold for grievous bodily harm. And as a result, the court should find it especially restrictive and difficult to validate consent as a defense for the infliction of grievous bodily harm. In the interest of time, perhaps I could briefly read out a quote from the case of BM in paragraph 39, which states that serious injury, even consented to, brings with it unwanted injury, disease, or even death, or in any case, social cost. This is a uniquely higher threshold that does warrant the restriction in some cases, unfortunately, of bodily autonomy. But furthermore, it is submitted that bodily autonomy alone cannot be a restriction on the power of the courts to implement its power and duty to guard against the risk of serious harm. We see this in a lot of—
I'm sorry to interrupt you, Ms. Yeung. Can you just give me that reference again?
For sure, my lady. This is page 45, paragraph 39 in the case of BM.
Thank you so much.
My lords and ladies, I am aware of the
I've
time.
run out of time.
Yes, that's completely fine. I'm grateful. If there is no way I can further assist your lordships and ladyships, that concludes my submissions.
Thank you very much indeed, Miss Yeung. The court will now retire to consider its decision both on a legal and a moot basis. If we can invite both counsel for the appellant and the respondent to vacate the virtual courtroom, and as soon as we have reached our decision, we will invite you back in. But thank you both very much indeed for the submissions both of you have very eloquently made this afternoon to their lordships and ladyships. Thank you. This is the unanimous decision of a 4-member panel of the Supreme Court of Justice in the case of Mr. Mark Newman against the Crown. This matter came before our lordships and her ladyship this afternoon in light of a question of law which had been certified by the Court of Appeal in the following terms: whether a medical practitioner who administers treatment to a patient which evidence shows either carries no clinical benefit or which has an overall detrimental effect on that patient's physical health can nonetheless rely on the patient's consent as a defence to a charge under the 1861 Act. The facts are well known to all parties here. In effect, what is said is that Mr. Newman carried out a procedure which carried benefit to his patient, a professional cricketer. We have been referred to a number of very well-known authorities, the main authority being that of the Crown against Brown, a decision of this House some number of years ago. In the course of submissions today, Miss Lane, on behalf of the appellant, has urged upon us to, in effect, say that Brown can be distinguished, that the conduct complained of here falls within an exception, or alternatively, we should create our own exception on the facts of this case. Miss Yeung, on behalf of the respondent, replied or responded that the law is extremely well established here, that to entertain the appellant's submissions would in effect be opening the floodgates here, and what we have here is in effect certainty as to where the law stands, certainty being required so that the members of the public can go about their business knowing where they stand so far as the line of law is concerned, and that they should not trespass it in those circumstances. My lords and lady considered the submissions. We have taken into account the skeleton arguments. We have considered the very eloquent oral submissions made by both counsel this afternoon. It is, however, a unanimous decision of this House that the appeal should be dismissed. Our reasons for this are as follows. First of all, there is very clear authority in the decision of Brown and BM that one cannot consent to a charge of grievous bodily harm except in those very limited circumstances. We find as a fact that the conduct mentioned here does not fall within any of those categories of exception. What we have here is in effect an individual who perhaps by virtue of his position and role in society chose as a vanity project to have a procedure which in effect allowed him to participate in an event which otherwise he would have been prevented from playing in by virtue of only a period of 5 months. We find that there was absolutely no necessity at all for this procedure to take place. This was, as we have already observed, was a vanity project on the part of the cricketer, which was in effect indulged by Mr. Newman for no good clinical reason. So far as it may be said that this arises out of a sporting event, we dismiss that submission on the basis that in the case of Barnes, that was a spur of the moment activity or event set against the rules of the game of football. Here we have a defined clinical attempt and decision which is taken so far away from the field of sport or play that it cannot fit anywhere within the confines or the restrictions or exceptions of a sporting event. Finally, if we do need to comment upon it, this we find would in effect open the floodgates to people who have the benefit or the ability to carry out life-changing or body-changing procedures. The court should and does mark a line in the sand as to where that conduct falls. And we find for those reasons that the conduct complained of does indeed fall within the ambit of criminal law. And therefore, for those reasons, we certify the question as saying that consent cannot be given in those circumstances, and the appeal is therefore dismissed. That deals with the legal issues. So far as the moot is concerned, you will gather from the time that we took dealing with the matter, it was an extremely close run event for all of us. With that in mind, we did address the marking criteria very closely to come to our decision. To put everyone out of their anticipation, we find that Miss Yeung is the winner of the mooting element. Our reasons for that are in effect under these broad headings. First of all, we found that Miss Yeung dealt with the judicial intervention in an extremely comprehensive way. All of us were extremely impressed by the way that she interwove her existing submissions and dealt with those dealing with the judicial intervention. We were all very impressed with the sophistication of Miss Yeung's argument. Though she had been provided with, in effect, a template and a backdrop by which to address the court, we were extremely impressed with the way that she brought that to life with the sophistication of her argument and the broader principles which are at play here. By way of presentation, we find that both counsel or competitors today probably were equally marked or balanced so far as their presentation was concerned. We did find that Miss Yeung, as she developed her argument, she settled very comfortably into that role. She then adopted a very nice pace, and what I think we were left with at the end of the submissions was a case where we knew exactly what the respondent's case was, and for those reasons, we find from the mooting perspective, Miss Yeung is the winner. We should, however, also applaud Miss Lane. Miss Lane certainly acquitted herself extremely well. She had a very difficult legal argument to develop, and she certainly deployed all the arguments available to her. But because it was so close, we did go back to the marking criteria, and for those reasons, we find that Miss Yeung is the winner of the mooting element. But on behalf of all judges, we congratulate everyone for attending today, and in particular Miss Lane and Miss Yeung for reaching the final, and of course Miss Yeung for being the eventual winner of the competition. So thank you very much indeed.
Thank you very much, and
Thank
well
you.
done.
Thank you so much.
Thank you, Matt, for such a comprehensive judgment there, both on the law and the moot. Well done to both competitors in the final. Congratulations, Miss Yeung. Commiserations, Miss Lane. You've both done extremely well, so you should be really proud of your performances there.